Court does call the case of the Park at River Woods versus Joseph Davis.
Good afternoon, Your Honor.
Tracy Jensen on behalf of the defendant, and I have my co-counsel Jill Bauer here with me.
All right. Where are we on this case? I set this for a show cause because we weren't able to get anywhere. Did he let them in?
So, Your Honor, I cannot see a response, or I'm just now seeing on my phone a response. We filed a motion for reconsideration based on additional.
You can have my copy.
I will.
My copy of my, because this came in moments before the hearing and I've denied it.
I apologize, Your Honor, for the inconvenience to you and to counsel. I would like to explain that the Section 8 packet for this tenant to move was completed and confirmed to me by the director of the Animal Housing Commission this morning. The inspection for the new place is taking place this afternoon, so that was confirmed to me personally. So I think within a matter of days, he will be able to vacate. He is currently at the hospital right now, and I would like the opportunity to speak at the bench about further issues for this decorated disabled veteran.
Well, I think, and certainly Ms. Jensen, while I trust you, I'm not sure that I trust what your client is telling you and the information that's then being provided, because this is now my third hearing, I think, in regard to just this furnace issue, which you raised before the court. I instructed plaintiff what they needed to do. We had come up with basically how this could occur. We set that up. And it was something your client didn't do. Plaintiff adjusted to it. And he still didn't do something. Then he was making demands of not letting certain other people that were necessary to get that furnace certified into the unit, or didn't want them in the unit. We then go back and we set it all again.
Your Honor, I appreciate I truly appreciate the court's efforts to shepherd this through. A couple of responses. The nature of his disability, I think in the texts that I'm happy to show to the court again, show his efforts and intentions based on his abilities. I also would renew my request to talk at the bench about some additional things that are happening in this case. I actually was waiting on a piece of evidence to file this motion. And it didn't come, but it wasn't something that was the tenant's word. It's just trying to operate and get the best information to put forward the case for this client, which I think is compelling. So
I am, but hang on. I certainly am taken by the case, by Mr. Davis's position. I appreciate him as a veteran. I appreciate him certainly in terms of what limitations or other things he may have. But there comes a point in where it no longer looks like that the disability is what is interfering, but that it is indeed almost a willful manipulation that is occurring. And I don't jump to that conclusion lightly. It was that morning that plaintiff had set up to come in early. They were supposed to be someplace else. They were going to come in early. They then adjusted to try to come in. Nothing. It didn't happen. And then and he's making demands that really have nothing to do with what is the perceived disability. He was making demands of certain people coming in, certain people not. I could understand limitations on the number of people, but he's making that this person can't come in. Well, that person's absolutely necessary to getting this furnace up and running. And the understanding that this was his complaint initially. I mean, everything was fine. A COC gets ordered. He then complains he doesn't have a furnace. And plaintiff is trying to resolve that issue, but can't.
So he went months without heat, and then he was working at the time of the city inspection and sort of failed that night. In terms of who can enter, there's a maintenance staff person who is also a combat veteran, who's a safe person for him, and a couple of other maintenance people that just felt like safe people to enter. And I can talk more about the issues in this case, and if Your Honor, declines to speak privately, of course, I understand. But I would then just, assure the court that the Ann Arbor Housing Commission has approved a new place. The inspection's taking place this afternoon, so I think that he can be out in a matter of days, and I think that that's probably in the best interest of all parties.
It's not copying anything.
Your Honor, I would briefly just state, if the tenant's going to vacate and we can have an order indicating that he will vacate within 3 days or whatever it is, I mean, we're not going to oppose that. We have the financial issues. And I would just state for the court, I've only been in this case for a short time, but what I've seen since I've been in is every time we tried to get in, there was an issue. So I think, again, to keep this brief, yes, if he's going to vacate, I don't know why he's not here today. I think there was a court order for him to be here today.
He was.
That's for the court to determine. At this point, we can take our unit back, determine how much is owed. That's what the landlord was seeking in the first place. So we won't oppose that.
What date would he be out?
Well, if the inspection is approved, I think probably be within a week. I've been led to believe that's going to happen.
And the only problem, Your Honor, is every time we think something's going to happen, it doesn't. And I stopped the day after court. They tried to get in, couldn't get in. I said, just stop trying at this point. We have a hearing. He'll be here. We can figure it out. And here we are.
Yeah, and he did reach out. He did reach out by text many times after that to his trusted people, got no responses, and then finally talked to a property manager yesterday that said, who I think told him she'd been instructed by counsel not to talk to him. So at that point, it seemed to just stall.
Well,
I don't believe, Your Honor, that I instructed the client not to talk to him, but I just said at this point, we do have a court hearing. So
yeah, I mean, and quite frankly, I get plaintiff's position, even if she had instructed don't deal with them, because it hasn't gotten anywhere. I mean, I'm frustrated because this was basically a 3-step process that all had to happen in a particular order, and it should have been done.
And that may have been more than was able without probably my being there personally to shepherd it. And this client went months without heat and had other issues that I think created some of the decompensation that's happening. But again, I'm happy to.
Let's do this. When will he be out? I mean, I'm going to need a firm date because I'm not, and then quite frankly, I'm not sure that I want it contingent upon anything. It's just, I just need an absolute. He's going to be out because those kinds of orders are easy for me to enforce.
Your Honor, if I could have a moment to step out and try to get a date from the social worker.
Okay, is the inspections today? What time is the inspection on his new unit supposed to
In
happen?
the text I said it says it's happening. Hold on a second, let me get my glasses on. It's happening today. I'm sorry,
No, it's okay.
using my phone is like, I don't do as well as my 18-year-old.
Okay, I'll be right back, Your Honor.
Okay. So what are you checking on?
I'm calling the social worker to see if they can give us a firm date.
Okay, and so,
Because what you're asking for, I think, is if for some reason the house fails, the housing inspection fails for Section 8, which I don't think it's going to. I think we'll know this afternoon that it hasn't. But of
well,
course,
that's what I'm
that-
asking for. So when is the inspection taking place? Because if the inspection is taking place at 2, it's not gonna take that long. I'd rather wait. Find out if it failed or passed, and let's do a date or figure out something. I just need something firm in this case that says, this is what's going to happen.
Okay.
And that if it doesn't happen, then I send people dressed like my bailiff to make it happen, because that's what we do. Well, no, we do other things. That was kind of rude. I didn't like that line you just wrote for me. Damn. Just let it go. I am.
All right, I have texted, I could step out to call.
Yes, I'll stand in brief recess then, and we'll at least get that part resolved. Or stand in recess.
Thank you.
Thank you.
Back in the case of the Park at River Woods versus Joseph Davis.
Again, with the record, Your Honor, sure, I'll walk up on behalf of the plaintiff.
Tracy Jensen for the defendant with Jill Bauer,
All right, and you guys were
Yeah.
finding out information.
3 p.m.
Is the inspection?
Yep.
When,
Your Honor, I have a hearing right now that I need to go log into in another court in your conference room.
okay. And when did they say they could get him out? You were checking on that, Ms. Bauer?
Well, I think if we did 2 weeks, we would be safe that everything could happen within that window. So we would be requesting May 10th.
Okay, so folks, look, we're gonna have to get real firm on this date because I don't like May 10th. Not the day itself, but I don't like that time frame. Because I get a motion that says he can be out in a few days. Then now, a few days is not 2 weeks.
No, I understand.
The inspection is today. And we should know whether that apartment passes.
Yes.
Then, once we determine that apartment passes, there should be no issue with him then moving.
I think a week then, I mean, if it passes, he can be out in a week. I mean, if you want sooner, I think 96 hours is the most, but we're running into the weekend, so.
But I think the concern is when his pension available to make sure that he has enough money for that security deposit.
The VA will pay his security deposit if necessary.
I'm new to the VA cases, Your Honor, so.
Okay, but they will, okay,
So-
look, folks. I get it that maybe we're all giving our best guesses. I'm gonna be insistent on it at this point. We just need to be firm and a date. I'm not looking at May 10th, I'm looking at May 1. So that if he doesn't move, Plaintiff's counsel will be here May 2nd. They can get a judgment and a writ that same day. That's quite frankly the time frame I'm looking at. And I developed that time frame in my head based upon the fact of what is contained with regard to the move out that you have
Yeah.
in the motion that you filed with this court.
Yeah, that's what I've been told previously. Of course, if it's not, I think it's going to be approved. Of course, if it's not, I.
Okay, but see, no, and I get that, Ms. Jensen, but I keep coming back on this case where one thing happens and then next thing you know, we're off into some land of twilight and then we're back trying to figure out where we're gonna go. And I'm not going there again. I'm just not gonna do it. So here's what I'm gonna do. That inspection should not take more than 15, 20 minutes. Ms. Luckoff, can you go handle your hearing, be
Yeah.
there? We'll reconvene at shortly after 3, see where they are on the inspection. You guys need to get somebody that's gonna be at that inspection so that they can let us know whether it passed.
I'm on.
Thank you. I'm back in recess. And so don't turn off the system, Ann. You just did.
I know.
All right,
After
14A District Court, County of Washington, State of Michigan, session.
All right, you may be seated. Where are we?
So, Your Honor, the Ann Arbor Housing Commission confirmed, so the house looked good. It technically failed because some plates have to be replaced. So,
Plates.
like electrical plates, just the plates aren't right. So, the landlord's gonna do that after hours tonight and submit photos in the morning. So we think it's gonna pass tomorrow. I mean, there's just,
Are they going out tomorrow to redo the inspection?
no, they'll accept my photos. So I guess, was hoping we could, conditionally dismiss just with a vacate date. May 3rd, talk to the client May 3rd. I think Ms. Luckoff has a different perspective. She has
Your
a
Honor.
different ask of you, Your Honor.
Your Honor, I would at this juncture ask the court to enter a judgment with a move out date of May 1st. We've just been back over and over on this as a possession case. To have to do a conditional dismissal if the tenant doesn't move, more work on my part, more cost for my client. And I don't see any basis now. So I would ask for entry of a judgment.
So, yeah, some of the reason I was going just for the vacate date is I know there are money issues and I was just trying to get the vacate date, so like a mutual dismissal without prejudice, I guess. He has counterclaims. She counsel claims that he owes rent. So,
Well, hold it, folks.
I guess I would withdraw the counterclaims.
Okay. That's okay, that's great. The question is how much is he going to owe? Do we know?
Well, I know what the balance is on the ledger, so I guess we can
Yeah.
start with that. Yeah, I had this up last.
I mean, it's part of, I guess what I'm saying is, part of his agreement to move, he's going to agree to their amount. I mean, look, folks, the last thing that he wants is a circumstance where he has a trial on this. Because I think there are going to be huge issues with what has transpired over these past week or so. So I get the fact you withdraw the counterclaims. I think that's where we were. Then the issue becomes, when is he going to move and how much is owing? Because however that's calculated, what we know is he's going to pay whatever part, and then there's going to be issues regarding the VA. We had been assured by the representative from the VA that whatever's due and owing, they're going to make it good. So, and my dealing with the VA in the past, they always make good. So I'm not so much worried about that. I just want to not have to be back here on what the amount is.
Well, Your Honor, right now, the balance is showing at $3,239.70, and this is the ledger that was provided to the court.
Court.
And that's because he was abated, I mean, he's still technically under abatement, but Your Honor had said sort of April 1st. I mean, this is what I was, so I would think this would be in the hundreds of dollars instead of thousands.
Well, hold on. I don't know that that's true anymore, because part of what remember when we had the discussion about rent before, we were talking about the 1st or 15th of April when it would click back on. But that was because the repairs had not been completed. And when then the Ann Arbor Housing Commission could click the rent back on or click the subsidy back on. The problem here now is this could have been taken care of a long time ago, except that it's the tenant that is interfering with completion.
Well, I think the tenant, everything passed for the city in March, and then there was this new issue. So
That's where
the
we came to.
landlord didn't complete the work in the unit until, I mean, I was there that day. There was pizza, there was.
Mind you, Your Honor, the reason it wasn't completed until May is because the landlord couldn't get in. We had episode after episode where we were refused entry.
Oh, I know.
So, but, okay. Try that. So I think it was March. I'm sorry, if I said May, I was mistaken, but then you said May, and you mirrored me saying, it's March. March is when it took place. There were multiple attempts prior to that. I mean, the narrative of the case goes a lot of different ways, and
What's his monthly rent?
Your Honor, the monthly rent is, well, the section 8 portion is $748 and his is $149. So together that is $897.
All right, folks. He's going to owe for all of April. The problem here is going to be that normally that 748 would have been covered to some point, but it's not fair that I say the landlord has to eat that or do whatever, because he is the cause of it. And I also can't say that everybody hasn't tried to accommodate it in some way. And so he's the delay. He's going to owe all of March.
So he, this is somebody, I mean, a ceiling fell on his head, and there are other issues.
Your Honor, we're not going back.
Well,
I mean, let's talk about the abatement was all the way through.
Counsel, and I don't mean to interrupt you. We were here the last time that we were here. Defendant was going to withdraw his counterclaims. The only issue became once the individuals got into the premises, did the furnace, how far back would the Housing Commission go? Would they pay all of April or April, or would they only pay part of April? What were they going to do? And then what we're going to do with that? Now I understand all that part. That was also, however, in looking at this, we were thinking that he was going to be in that unit for a certain period in time. We knew there was going to be a gap of payment versus whatever, but that was solely because of what part had been abated, getting in to do the inspection. But he can't, in this instance, delay the inspection or delay the repairs, which delays the inspection, which would turn back on the subsidy. He can't do that. And so while it may seem unfair, I don't think it is unfair. He's the reason we're here today and have been here on something that should have been simple for the last 3 hours. Then we get here today, by the way, after we think he's going to be in for a few months or at least a month. And we find out he now wants to move in a number of days. And that, I begin to feel like Don Quixote in the windmills, is the date that is moving. Because you told me one thing in the motion, then council is giving her best guess, but they're saying 2 weeks. And then that's all contingent upon this inspection. Then the inspection doesn't happen. Now you're telling me that it needs to be wall plates and that should be done tomorrow. They'll accept it by photos and then we'll be able to approve the unit. And I don't even know that that's gonna.
I hear you. I believe it'll happen, Your Honor. But
I know, and I believe in unicorns and rainbows and little candies dropping from the sky. Sometimes it doesn't happen for me. So I need something a little bit more concrete. Like,
Your Honor, can I clarify?
about the unicorns?
No.
Okay, no.
Just, you don't know me as well, and I just wanted to say when
So now you want to talk to me and verify something really? Probably not a good way
No,
to start your
I-
argument, but go ahead.
when you sent me out in the hallway to try to get information about dates and everything, I was getting a lot of different information. I was just trying to give you my best guess when everything could happen within. So I didn't want you to find me as not credible when I came back with it.
No. And counsel, if that's what you took from it, that's not what I meant. What I meant is I need a date nailed down.
Yeah, and I was trying to give you like the date that I felt confident that all the moving parts would fall into place. So I didn't want you to think that I was casually adding days.
No, and that's not what I was thinking.
Okay.
You just picked a date I didn't like.
Okay, I just wanted to clarify that so that I would feel better about it.
Okay, well, don't feel bad.
so, it's our position that he would vacate, or we would ask that he be allowed to vacate on May 3rd, but it sounds like Your Honor.
Why is the 3rd important? As opposed to the 1st?
I think that's what's, I don't know. Do you have a specific reason? Just gathering together and moving and.
He's concerned about having enough financial resources for all the things that are going to be encompassed in the move, and he will get a check on May 1st.
That's May.
So that's why he asked for May 3rd.
Yeah, it's 1 week. So.
I think it's got to be May 1st.
Okay.
Because what's going to end up happening is the landlord probably has a unit that they could then, once he's out, be able to re-rent and move on. He will be someplace, provided it is these wall plates that need to be replaced. He will then be someplace that he can be, and the parties can part ways and go on about what they would need to do. So can that happen?
Oh, my heavens, I'm so sorry.
Sorry.
All my speakers in that was an alarm. Well, I think if Your Honor orders it,
I mean, my alternative, because he's not here for a show cause that I demanded in person, and I understand it, is to do that or begin daily sanctions of him until he complies with the court's order, which also would not be something I think he would want. So none of his choices from his perspective may be good, but those are his choices.
I mean, it sounds like May 1st is what the court will find.
All right, so here's what I'm going to order. The counterclaims are withdrawn. Defendant to vacate the premises by May 1st. If not, then plaintiff on May 2nd may present to the court a judgment and writ for simultaneous entry in the court, so that the record's clear, is going to find that any time period, particularly from the April 11th date when this matter was up for trial, the 10-day redemption period would have expired, and the defendant isn't intending to redeem in any event. He's intending to move. So I don't think that, in terms of compliance with the statute, I think that the court is in compliance with the statute. So they would get a judgment and writ that same date. The amount that he would owe, and I'm going to do it this way. There was an abatement because of certain conditions in the apartment. I am unclear, however. There came a point, and when you want to talk about March, where there's the COC. I'm not really dealing with the COC issue. When would they have turned on the subsidy, or when would the abatement have ceased, had he allowed entry into the premises?
Probably when the COC was issued, and I think that building has a COC.
Well, no, it wouldn't have been that.
It doesn't have a COC?
I don't think it's COC dependent.
Right. That's not,
I think that was,
that's why I'm not dealing with the COC issue. It, at some point, because the abatement didn't happen because there's no COC. There were certain conditions in that unit, and those conditions in that unit got repaired at some point. And had he permitted entry into the premises, that would have been the effective date that could have been turned back on. Now, there might have been other defenses, but I'm not going to deal with those. I'm trying to figure out dollar-wise why, when should that have happened? Because he hasn't paid and the subsidy hasn't come. So, I mean, there are two things that, in terms of payment, that haven't happened.
So, I mean, 3/29 is when they issued the COC, everything was done.
Your Honor, I completely disagree. I'm looking at emails mid-March where he wasn't letting them in. I mean, if you give me a minute, I can get you a date. But this went on for a very long time where we couldn't get in. And I do think that's relevant. Well, give me 5 minutes to come up to.
That's fine. That's fine. If I can get a date.
Okay. Thank you.
I'll just stay here, but we'll be in recess, I think.
David, Court County, Washington, State of Michigan, is back in session. I'm not going to take that.
You may be seated. Okay, council is present on the Parket Riverwoods versus Davis matter. And what did we come up with?
Thank you, Your Honor. Your Honor, the relevant dates, we believe, for the court. On December 22nd, the landlord tried to enter, and Mr. Davis was extremely hostile. I have an email from my client. And then the next time it looks like they tried to go in and really started to try and do things was February 17th, and that's when I was involved. And I mean, it was adjourned because Belfour had to get in because it was so filthy and so forth and so on. So those are the dates we're working from as far as not being able to conduct repairs. And
Repairs or do whatever.
Your Honor, I have a series of emails about entry back from when Mr. Lando and was representing a thread I have that goes from like November to January, right before he withdrew, shows some back and forth and efforts of not showing when they were saying they were showing. And so I would just say that the pattern is multiple. You know, what happened in these Parker Riverwoods cases, I think, and I was talking to counsel about this on the break, you know, This is a disabled veteran, and I think that some disappointments that people feel or challenges of the frustration of the way these have played out is especially acute for him. So it sounds like you're leaning in the direction of a money judgment. I would.
I'm not saying that there needs to be a money judgment. I'm just saying I'm going to fix the amount because I'm not going to come back hearing all of these arguments again. I mean, at some point, that unit, had they been let in to do the repairs, would have been, there would not have been an issue. I'm not talking at this point the furnace, but there would not have been an issue. Everything would have been done. Everything at that point then being equal, the abatement would have ceased at some point. And that date is prior to April.
Well, except that like the Section 8 abatement also was based on the refrigerator, which didn't get replaced until I think March. So I would have to pull dates and things, but going back to December, I would object. I can pull out Section 8 paperwork about the reasons for the abatement. It wasn't just the furnace. Let me see if I can find
I
it.
know it wasn't just the furnace. I get that. The issue was, could they have done anything? I mean, Miss Jensen, I get what you're, but we have to be realistic. He certainly has his issues in terms of people entering. Everybody is trying to accommodate the best we can regarding the issues that at least as they're reporting to us. But what this exercise that we've been going through over the last, since April 11th, has shown me is that it's not just his disability. I said this at the very beginning. At some point, that's being used to manipulate this. And to say that the landlord isn't doing X, the landlord's not doing whatever. Well, that's the problem when then you have the judge sitting in the middle monitoring almost in minute detail what's going on with a particular case, because then you can't make that argument. And I think that that has probably been occurring previous to this point in time. Now, there is a 3,239 according to the ledger. And his portion is 149 or yes, 149, right?
Yes.
So the figure I'm going to propose, it should be 4, right? Is 1943. Here, so that I'm told. And just so that you know how I got to that. What I'm doing, and I don't think it's necessarily guesswork, but it's taking the approximation of some of these dates. And just, I think, general principles of fairness. March and April should be paid in their entirety. That would bring me to 1794. And then his portion, which is 149 for the month of February, which would then bring me to 1943. It's not exact, but I think that that's a fair resolution given the dates, and I'm looking at this February 17th date particularly of his not permitting entry, because obviously there's a lot going on at that point with all of the units. at that point, so they just can't run around. So
Your Honor, would you like an order stating that tenant shall vacate by May 1st? And the amount due and owing is this 1943?
that's what I would like, but I want to hear what counsel for Mr. Davis has to say regarding that number and how the court arrived at it.
There was no city inspection. There was, I guess I think it would. I don't know. I don't exactly know how to answer. I think Your Honor has, it sounds like Your Honor has ruled. I would.
No, counsel, when I rule,
Understand more that I would understand more the April. I mean, this is I was talking to Ms. Luckoff as well. I mean, this is a disabled veteran. He has 9 commendation medals. And I understand that Your Honor feels that the disability is conflated with some kind of interference in the process of getting.
hold it. Don't twist my words.
Oh,
Here's what I said. Here's what I said. I said, everybody has gone through the accommodation, but what has become clear to me, and including the court itself, if you recall, you asked for an accommodation on the 11th for a hearing to be moved to a point where there were not people in the courtroom. We moved that hearing from where the other hearings were to the afternoon, making sure that it would be clear and so that he could walk into the courtroom and not have his problem. So don't make it seem like I'm not acknowledging his disability and his challenges. I do. But at some point, those challenges, as have been exemplified over this past week, 2 weeks, become part of a manipulation. And I dare say not only a manipulation of this process, this court, the landlord, but quite frankly, counsel, I think you too, because he gave you certain assurances when we were on Zoom. He told you this was going to happen. And on at least 2 occasions, he failed to do that. And I appreciate the fact that you want to fall on the sword for him. I get it. But at some point, all of that has to end. There are a lot of people out there that have disabilities of various types. Various challenges then get created by that. And I think it's incumbent upon all of us to work with those individuals to overcome that. But that doesn't mean everybody else then has to sit back and be manipulated by it. And that is what I see has occurred. So it's not an issue of necessarily conflating it in the court's mind. I think that he has turned this into a point of attempting to try to manipulate everyone here.
And Your Honor, I'd like to hear, if Ms. Jensen has an objection, I'd like it placed on the record now because I don't want to have a motion for reconsideration the next step here. So let's just flush out the issues if we can.
That's why I'm still here at 4:30 on this case. I want it all done.
I would object to his owing rent theory, and I would sort of object, and the part that would be, I would object to his being charged March rent. It was under a Section 8 abatement. I think the Section 8 was not going to pull it out of abatement without the refrigerator. So it's not just about the furnace.
When was the refrigerator put in?
Let me look.
And I maintain, and I think Ms. Jensen remembers, we tried to get in and then we couldn't get in because Belfour couldn't get there because it was too dirty, and that's when it all started in February. So I don't know off the top of my head when the refrigerator.
That was March, I really.
No, I
do.
have the email. It's not playing my computer. Excuse me, turn that back.
Sure.
So I have on the 17th of February, and I'll leave out some of the graphic unpleasantness of the unit, but we're able to take care of one thing: self-closing door, replace GFI, fix the leak, replace plate cover, shampoo the carpet as best we could, painters patched and painted. And then I just want to confirm, because I know that Belfour was coming in, and I want to make sure that I'm correct.
So many notes from the repairs that, that was March, I think.
That seems to me, that was, if nothing else, when the bulk of repairs were actually done.
And that was February 17th.
Joe. So as I look back at timelines, so the unit was originally abated for not having heat, air conditioning, and then the refrigerator issue, and then repair damage at the seam on the ceiling and the secured bowed drywall. That Section 8 inspection was in June of 2022, and the abatement started in July of 2022. At that point, with the support of the social worker, there were 4 attempts, or multiple, at least 4 that I know about, attempts to reach out to the landlord and get resolution, and it didn't move forward. I think he had a lack of heat for some time before that, but of course that was a different owner. And then the furnace was fixed enough so that it was like working for the COC city inspection. But I have an email I sent to Mr. Myers on March 6th that says, as soon as you left the apartment last week, the heat stopped working. He notified the landlord he was given a space heater. And then,
Which, Your Honor, I would say, as the court indicated before, things happened. The heat went out. It was fixed, it went out. And now we've been trying to fix it now since then.
so, the city didn't, so Mr. Myers didn't go back and like take away the approval because their approval was that it was decided, so he wasn't gonna reopen based on the furnace. It just moved forward as a let's get the furnace done. So on March 17th, it was approved, the COC was issued on March 29th. So if those dates are helpful to the court.
It was approved when?
March 17th. And the COC was issued on March 29th, according to the BSNA.
Right, but that was, which is how I'm coming up with my dates. Because what I'm saying is, they're not able to get in. There's a framework of the February and March period of time. Had they be able to get in and do the repairs, that everything would have been set for March and April. And I think that that's certainly what's due. I think there's also fault on the defendant's part for what is happening in February. And even at that, I'm not saying take half of the rent due in February. I'm saying pay his portion, which is the 149. And that's how I'm coming up with, in great part, and it seems to fit with what both parties are saying, the March and April, and then his portion of February. And I'm not saying even go back before then in terms of their ability to get in or anything like that. Everybody's going to have their story. But that's where I'm coming up with this figure.
Yeah. I guess I would. Sorry, Your Honor, I'm just trying to wrap my head around all the dates and the facts. I think I guess I would just object to any rent being charged to him before April 1st. Because I think April 1st, there was a period of real question. But
is there an amount that you can agree on? Did you need to call your client and try to find out if there's an amount that you can agree on?
I don't believe he's necessary. I mean, he's a Section 8 person, so I don't believe there's going to be a great number of funds. And given his move out, I can't imagine that the VA's county office would issue payment to a landlord, someone that, when someone's not actually going to remain in the unit. So, but I'm happy to call him and talk to see if he would agree to any of this. I almost feel like I have to.
Then why don't we go ahead?
Okay. I would just like to state, there's been an 8-month abatement, okay, in this unit, just so we're all clear. The tenant has never paid a penny.
I know.
Okay? If there are some facts that the defendant wants to present to, I'm happy to listen to them, but I know since I've been involved, it has been a nightmare to get into this unit. Even the inspection was delayed because we couldn't get into the unit. Now, at the end of the day, he's moving. We can come to an agreement, great, but I don't hear any factual basis. I hear, so you're trying to wrap your head around it, all that. And I understand this wasn't something you were prepared to deal with today, and I respect that. But if there's a fact that can be presented, I'm not hearing it. I don't think the COC has any relevance to this. So my client, I'll ask him, but we have our records. We have a record of not being able to get in December, and we have a record of getting a tremendous amount done in February. And then, as I said, since I've been involved, I cannot tell you how many hours I've spent on trying to get into Mr. Davis's unit. So,
this, I would question whether full rent would be merited to be owed when portions over a long period of time were not adequate in the apartment, but I will step aside.
And Your Honor, he lived there. Is my understanding is that they even offered him to move. So he lived there for 10 months for free. And anyways, I'll be happy to call my client, Your Honor.
All right. And you're going to try to call your client, right? All right. Thank you. Order stand in brief recess. Okay, the court is back in session. And Ms. Jensen and Ms. Luckoff are present in case Riverwoods versus Joseph Davis. All right. Yes, go ahead.
Okay, I spoke to my client and they're willing to waive Mr. Davis's portion of February. So just be March and April, the number of the 1794 that you came up with?
Yes, they're willing to do that. Okay.
So, in as much as Mr. Davis believes that he should pay his portion for the 1 month when the furnace broke or worked before it broke again. So there's a difference between, and there wasn't any back and forth, but he's willing to pay 149, which is his portion.
Here's what I'm going to do so that we can be done with this. He was directed to appear at these proceedings. I understand, as I have gone through with great difficulty explaining how the court has taken that into account. I'm going to, because it's a lower and greater benefit to the defendant now, I'm going to just indicate that the amount of rent due will be the March and April rent, which will come to the 1794 plus costs in this case, which will be the amount that the defendant owes. I would indicate also this, that the defendant's failure to appear, the court will reserve its right to impose sanctions for his failure to appear and not comply with what is the ruling of the court, because he was to be here today. So,
Your Honor, he did offer partway through to appear by Zoom, and
that was not the court's order. I understand what you're going to argue. You argued it in the motion to reconsider. The court's order was he was to be here.
I did file an ADA complaint or request and was waiting on a piece of evidence that I never got. So I apologize.
And the court ruled on your motion for reconsideration. He was to be here. All right. Thank you.
Thank you, Your Honor.
Your Honor.